Is the non-custodial parent responsible for transportation? When parents separate or divorce, one issue that often creates friction is how their child will get between homes. The answer isn't always straightforward. Especially in Texas, where families often live miles apart, defining these responsibilities early can prevent conflict down the road. Legal obligations for transportation in Texas law outlines clear obligations for the non-custodial parent, also known as the possessory conservator. Under the Texas Family Code, transportation duties often fall to the parent who is exercising visitation at that time. If the court order does not state otherwise, the non-custodial parent is expected to handle pickup and drop-off. Standard arrangements typically require pickup at the custodial parent's home or the child's school, depending on the schedule. If a non-custodial parent cannot transport the child, they may designate another responsible adult. But they are legally required to inform the custodial parent. If either parent repeatedly fails to follow the agreement, legal consequences such as contempt of court can apply. A lawyer can help clarify these obligations and avoid violations. Is the non-custodial parent responsible for transportation? Yes, in most cases, the non-custodial parent is responsible for transportation during their designated parenting time. If the custody agreement doesn't explicitly say who handles it, the default expectation usually places this duty on the visiting parent. However, both parents can negotiate and agree to a shared approach or alternative arrangements. If one parent moves or if the child's schedule changes, transportation responsibilities can be modified. This must be done legally through the court to ensure the new terms are enforceable. When disputes arise, parents often return to court to seek clarification or changes in the existing transportation plan. Understanding the process for transportation responsibilities, a non-custodial parent has several rights and duties that come into play during their possession time. They can make decisions about the child's moral or religious instruction, attend school events, and manage emergency care. All of these responsibilities are tied closely to the logistics of picking up and dropping off the child. If the child cannot be transported on schedule, the non-custodial parent must notify both the custodial parent and the child's school. The law also allows for flexibility. Parents can agree to adjust schedules as needed, as long as both sides consent. Travel costs can be another source of stress, especially when parents live far apart. The parent who is exercising visitation usually pays, but many custody agreements allow for splitting those costs. Addressing transportation costs clearly in the custody order helps reduce conflict and surprises later on. The law aims to protect the child's best interests. Whether that means adjusting the pickup location or enforcing missed visitations, every decision should focus on the child's well-being, not parental convenience. An attorney can help ensure the transportation plan supports that goal. To navigate the legal requirements and protect your rights, it's best to work with a law firm experienced in child custody matters. If your current arrangement isn't working, a lawyer can help petition for changes that better suit your family's needs. Family Matters law firm PLLC is here to help with every step. Call 210-997-2914 or visit us at 926 Chulie Drive, San Antonio, Texas, 78216, United States to schedule a consultation and learn how we can support you.